Anna, if you could go to the next two slides, that would be great. So today we have a very full agenda, and we're really excited about it. We've been participating in this ongoing research, public opinion research, and so we're going to kick off our day with Nancy Belden, who will give us an overview of those findings from focus groups and survey research. And then we're going to go and have some Q&A for that. Then we're going to turn it over to some consortium member updates. And then at the end, we'll have more Q&A and announcements. So without further ado, I'm going to turn it over to Nancy. And in advance, I apologize. We've received some snow here in DC, so we are having some technical difficulties. So Nancy, we're going to try and figure out which attendee number you are and unmute you so you will be able to speak. So Anna's going to go ahead and try to unmute a couple of you. So Nancy, if you just want to speak, then we will know when you are unmuted. Thanks.
Okay, caller number 21, you're unmuted, so could be Nancy. No, doesn't seem like it.
This is Nancy Belden. This is Nancy.
Great, I think we found you. Okay.
Great. Okay. Okay. So as Genevieve was saying, we've had a few technical difficulties, including the fact that I'm at home and I didn't successfully log in. So I'm asking my friends at American University and at the program to please change my slides for me, and I'll give you the number as we go. But thank you very much for having us here and for having us undertake this research. If you'll go to slide 2, let me just say a little bit about what we were aiming to do. The survey and focus groups were really to look at what the public believes currently about public defense and spending that might be useful to improve it. We wanted to document beliefs about how well the need is being met, and we will definitely talk about that as we go through the findings. We wanted to know something about support for things that could be done to help solve some of the limitations. And we want to identify values and information that could help us in messaging going forward to talk to the public about the importance of really adequately providing public defense. Let's go to the methods on the next page. We did 6 focus groups first in April. We went to Richmond and Columbus and Houston. We did groups with Latinos and Latinas, with white people and black people, with Republican men and women, and Democratic men and women separated into distinct groups so we could look at them. We followed that with a survey of 1,478 adults, including oversamples of African Americans and Latinos, so that we could really analyze them thoroughly. This was conducted using a panel called AmeriSpeak, which is a great panel that's come on into being in the last few years. It's a probability-based panel. It's online, but it's also supplemented with telephone. So it's really a great sample of the representative sample of the American public. And we did the interviewing in throughout September, ending the 1st of October. So next, just highlights four things that we're going to talk about today. One is that there really is a lot of public support for public defense. Most people, or a large majority, favored using tax money even to provide for it. Secondly, there's a lot of awareness of the need already. We don't need to be educating people about how much need there is. That most people think that there's at least one out of every 2, if not more, if not people need to have a lawyer provided to them because they cannot afford it. Thirdly, we found a lot of support for the reforms that we proposed. We put a few things on the table for people and talked about them and put them in the survey, and there was a lot of support for doing things that would improve defense. And finally, we'd look at the core values that are key to messaging about this need and how to get people to really sit up and think about it and care about it. Some of those are invoking the Constitution and beliefs in equal justice and desire to protect the innocent and so forth. So we'll come back to those just a bit. So let's start the next slide, 5, and then going to 6 about how much broad support there really is for public defense. We found we use the term tax dollars in our question about whether people would favor or oppose providing lawyers for those who cannot afford them, people accused of a crime who cannot afford a lawyer. We use tax dollars in order to make the question somewhat difficult, and we still get 62% saying that they favor spending taxes that way. Let's go to the next one. We also asked people in the survey about the importance of various programs, and if, we asked them a bunch of things that the states and federal governments might do to help people with low incomes. So we have Medicaid, Head Start, child care, food stamps, public defense lawyer, and rental assistance. And as you can see, public defense lawyer is not as popular as helping people with food and Head Start, things for children and so forth, and health care. Nevertheless, you still have 52% saying it's very important, another 33% saying somewhat. You have very strong numbers of people thinking that this is something that we need to do for people. So again, in the same vein, if you go to slide 8, we also asked people, again trying to make sure we fully understood this, whether people thought that they would favor their own state spending more tax dollars to improve public defense. And here you get, again, really big numbers, 21% saying they strongly favor and 40% somewhat. So you have, 6 in 10 are agreeing that their own state should be doing this. So if we just go to question to 9, we also tested this question, the same question I had on the previous slide, but this one speaks, we substituted in the words undocumented immigrants. And here you can see that the strongly favor falls way off to 12, the somewhat favor way off to 21. So it's not that the desire to help, the support for helping people is without question. There are certainly things that can undo that support, and bringing up one of the more contentious issues nowadays is certainly a good illustration of how that support is not necessarily always in place if we talk about all kinds of people. Okay, let's go to 10, our second point, which is that there is the widespread idea and belief that there's a need for public defenders, but there's some bit of mixed perceptions about how well qualified they are or how able they are to meet the need based on what the system provides for them. Let's look at 11 about what I'm talking about here. We asked people how well they thought their own state does in providing access for low-income people in the justice system, in the court system, or I'm sorry, to access to justice in the court system. And here the numbers are not so great. People don't think we're necessarily doing such a good job. You only have 5% saying that they think their state's doing an excellent job, 31% saying a good job. Most people say at least just a fair or poor or very poor. And the biggest bulk of people are just in that middling sort of fair, not so great, just fair position. So there is the underlying idea and presumption here that things are not necessarily being provided as they should be. Let's look at the next slide. Again, in the same, underlining the same idea, we asked people how often they thought people who are arrested and accused of a crime cannot afford to hire a lawyer. And fully half, 48% said most of the time, and another 39% said about half the time. So in essence, we have 9 in 10 almost saying that half or more of the people who get arrested, they think probably can't afford to hire a lawyer on their own. So big need, people think there's a big need. Let's go to the next slide, 13. I'm sorry, it's a little, got too much on the slide, so let me just tell you what it tells us here. we asked people whether they thought the public defenders generally had one characteristic or the opposite of it: well qualified, not qualified, experienced, inexperienced, etc. And what we found is that there's really a lot of mixed views on the quality of public defenders and then on the adequacy of them. On the one hand, I shouldn't say the quality, because on the one hand, 6 in 10 say that they are very well qualified. A small majority also says they think they generally are experienced professionals. But things after that start to fall apart a little bit, and particularly as we get down to the issue of whether or not they have enough resources, and especially whether they have enough time to devote to their clients. So here we find the public is quite pessimistic. So, you know, you want to just generally the idea here is that, well, they may be qualified, they may be experienced people that are being sent to these courtrooms and sent to meet with people, but we don't think that they really have the time or the resources to do the job they need to do. So what about solving some of this? Let's go to 14. There's a lot of support, and given what we've seen so far, that is the belief that there's a big need for supporting the public defenders, and there's a lot of need for providing them with the kind of resources they need and concern about it. So it's not surprising then that we found a lot of enthusiasm for reforms. Let's look at some of the things we asked about. We had 6 ideas that were put forward to our respondents, and they all got a strong vote of approval. 90% say, for example, that establishing a system of supervision and review is a good idea. 77% concur that there should be national standards for qualifications. 84% said that it should be a good idea to require states to assign a lawyer within 3 business days of arrest. This was something that in our focus groups just drove people up the wall, that people might languish in jail waiting for someone to come see them. We also had 85% saying they believe that national standards established for a minimal level of resources is a good idea. And that those would include things like expert witnesses, investigators, DNA testing, and so forth. These are all things that, once again, focus groups really went to town on wanting these things, saying that these things are what need to be there. And as you can see, everything that we put forward got a lot of support, particularly qualifications and standards and resources. So lots of support for improving things and providing some changes. Let's look at 16. We found, on the other hand, after all of my saying that, you know, showing you that there's a lot of support for doing these kinds of reforms, we also asked people about who they thought should take the lead here, whether it's the states or the federal government. And we found people are quite divided over whether federally or state-enforced public defense systems would be their preference. 50% agree more with the statement, and here I'm going to read you what we asked them. We said, you know, which of these do you agree with more? One is the federal government should require all 50 states to provide a qualified lawyer to every defendant that cannot afford one. And the other view, I should say, that people could pick was that each state should be allowed to determine how far it goes in providing lawyers to criminal defendants. So as you can see, looking at the pie here, that we basically have people split almost down the middle. This is an area of disagreement. It's the kind of split, of course, that we're seeing in lots of public policy currently. The focus groups, again, revealed this kind of division when we had just Republican, particularly Republican men in the room. They came down decidedly on the side of states taking the lead, and when we looked at, when we talked with Democrats, we had a lot more enthusiasm for a federal role here. So again, we have the underlying support and belief in doing the right thing, but how it's accomplished can be divisive. Okay, let's go to the next one. Our final section here is where we looked at, as we almost always do, is what is it that people really care about? What values rise to the top when we talk about the subject at hand? And here we found that the most important values and information that we could put forward in support of improving public defenders and their resources and everything they have going to help them achieve what they need to do are things like equal justice and fairness under the law, protecting the innocent, and particularly referencing the Constitution. So let me show you, if we go to the next one, some of what we did in our exercise here. We read some people some statements, or they read them online if they were taking the survey online, and we asked them how convincing they thought various arguments were for reasons why we need to spend more tax dollars on public defense. And we really found that 4 shared values emerged as key pieces of this and ways to communicate the importance of improving access to counsel. One is that public defense is a constitutional right. It comes up any number of times, and you're not seeing it on this particular slide, but it is something that we found. I'm sorry, it is here. Just not. It's not written out in the way that we'll show that, but it's the naming of the Constitution, and that it's a guaranteed right. Fundamental law is important. Another is that it serves the values of fairness and equal justice under the law. A third one is that it prevents innocent people from going to jail, and we also had some conversation around this about young people's lives not being hurt and drawn into a life of crime because of that. So those are things that are very important and helpful in discussing the need for more resources to go to public defense. Also, providing some pieces of information are helpful, particularly as you can see at the bottom of the screen there. We asked, in one version of the questionnaire, we said that public defenders often only have a couple of hours to give to each case. Some places another version. We tested a different version. We said that they only have 7 minutes per case. Both of those got essentially the same percentage which we've presented here, which is, basically 80% of people saying that's a really convincing reason to do something about this. So both values and some information are important. Let's go to the next slide. There's some other things that we put forward that were also important, but they didn't quite rise to as being, and they weren't seen as quite as convincing as reasons as why Americans value an effective public defense system. And they include the practical outcomes of good public defense. These can be important, things like reducing caseload, reducing over-incarceration, providing alternatives to incarceration, correcting racial unfairness. Some of those factual things and big outcomes to society and systems generally, but they're just not quite as first-tier top things that get people excited about doing something. So they're useful, but you would want to lead with the values particularly. So just summing up, if you want to just go forward, I think our analysis indicates that the information about the inadequacies of the system are important, but increasing the demand for change is really going to rely more on referencing those core values of protecting the innocent, the Constitution, fairness, and equal justice under the law. So I'm going to stop there and entertain questions from and toss this back to the moderators.
Great. Thank you so much, Nancy. And if people have any questions, please feel free to use the Q&A function, and then we can read them to Nancy for her to answer. And I also just wanted to make one quick announcement that we are hoping to release the report with the findings on a Thursday, so stay tuned for that. And does anyone have any questions?
We don't have any questions coming in right now, but it's possible that there might be some at the end of the webinar related to this.
I'll hang in here.
All right, great. Well, so if we don't have any questions at this time, please, if something comes up, use the Q&A and we will ask the questions later on. Nancy, we're going to go ahead and mute you again now, but Anna will unmute you if we get some questions come in.
Okay.
Oh, wait, it does actually look like.
Yeah, we just got a couple questions. So the first one is, has there ever been an opinion research on preferences between county and state control rather than state and federal?
Oh, there may be some. We don't have it. It would be a very interesting thing to delve into. I can tell you that generally public opinion reveals that whenever you get closer to home, for example, go from Congress to your congressman, or generally the public schools in the country, the public schools in your community, you always get more favorable views the closer you come to home. So it's conceivable that there would be even more support for local control, but I don't have that data, those data.
Okay. Another one, another person asked, was there a distinction made between public defenders and other defender systems? No, not particularly. Although at the beginning of the questionnaire, if I'm not mistaken, and I don't have it in front of me, I think we defined for people that some places have public defenders and some jurisdictions hire people. So I think that difference was established, but we didn't reference it throughout the questionnaire.
Yeah, and just to jump off of that, we definitely made an indication that when we referred to public defenders, we were referring to the overall system, but I believe that we found that most people weren't able to kind of distinguish the different systems and placed everybody in that overarching category, so sometimes it got a little bit more confusing when we added all of those layers.
Yeah, also I would say that in the focus groups, we saw that people had a maybe television-based, some of them, but also to some degree personally based, understanding of what public defenders do, that they are for people who can't afford a lawyer on their own and so forth. There was not a lot of confusion about the existence of some sort of system. But as Genevieve said, whether if they sit in an office that's just the public defender's office or whether they are people brought in is not necessarily something that was distinguishable.
Another question that just came in states, these results appear similar to a poll you all did back in the early 2000s. Why don't the results reflect the significant change represented by this last election?
Well, for one thing, the poll was done before the election. So I'm not sure what your question is. Can you want to read me that again?
It just says, these results appear similar to a poll you all did back in the early 2000s. Why don't the results reflect the significant change represented by this last election?
Well, they are very similar to what we found in the earlier survey. That's true. What that suggests to us is that opinions on this in this area are very stable. People are not particularly haven't had something happen to them that would have changed their view. As I said, we did the survey in October, so it was conducted before the election. It was in the midst of the campaign season. It's an interesting question whether or not the views might have changed given the sort of public mood and all the discussion that we've been having.
But I would be surprised if they have moved remarkably on this particular topic, given that it is a polarized environment that we're in, and the views in this survey are polarized to some degree as well. In each case, the Republican conservative base is more likely to, go the other way. Not entirely. That's why you see those big numbers in support of most of these things, but they are, less supportive. But it's a curious question, but I sort of doubt that we would have seen a lot on this particular issue, a lot of movement.
Yes, and also I think just to add to that, these results, while they asked people to rank kind of the importance of public defense among other social issues, they didn't ask people to rank public defense and these social issues relative to other factors that were going on in this, in our country. So I think that's also why it wasn't maybe another reason why these results weren't necessarily immediately reflected in election results or in how the election took place. And then Anna, I think we had one last question come in. Do you want to read that one? Sure. And then we will turn it over to consortium member updates.
The top response for supporting public defenders was quality should not be based on money. And the person asking this question just wants some clarification on what that response means.
I'm sorry, can you start over, read it again?
The top response for supporting public defenders was quality should not be based on money. And the person who is writing in would like some clarity on what that response means.
I'm sorry, do you understand the question? I'm not sure I understand the question.
So I think that the question is saying that the top response for why people support public defenders is saying that the quality of representation, the quality should not be based on money, and they just wanted a little clarity on what that means. My interpretation of that, and Nancy, correct me if I'm wrong, is simply that people were saying the quality of representation should not depend on whether somebody has the financial means to hire a private attorney. And so people supported public defenders because they felt that you should have quality representation regardless of your financial means.
Absolutely, absolutely. I think that that is something that is just a fundamental that people right from the left to the right agree with, and the focus groups, this is the kind of thing that came up spontaneously. People always reference sort of the OJ issue, and that's something that, again, a lot of what people know and think about this topic probably comes from their television exposure, and that whole idea that somebody could get off from something that the public thinks they were guilty of has been very illustrated to them in dramatizations as well as documentary sort of reporting. So it's just a very fundamental thing that I think cuts across all parties and types of people.
Excellent. Great. Thank you again so much, Nancy. And again, if people have more questions, you can continue to send them in the Q&A, and we can ask them at the end of the webinar. But without further ado, I'll turn it back over to Anna to go through some of our consortium member updates. Thanks.
Okay, so now we will be going over to Diane Price, who will be giving her member updates. So I'm going to unmute you, Diane, and give you control of the slides.
Great. So the first update I'm going to talk about is some of the updates that NACDL has to share, the National Association of Criminal Defense Lawyers, to those of you who may not be familiar with the acronym. Since our last meeting in October of last year, NACDL released its pretrial release manual for New Jersey. New Jersey in 2014 passed some legislation and a constitutional amendment to completely overhaul the state's pretrial release system, to adopt a pretrial risk assessment to better identify individuals who were low risk and could be safely released pending trial, as well as high-risk individuals who would be more appropriately detained without bond pending trial because of community safety concerns. So those new procedures went into effect on January 1st, 2017, and that includes public defenders at all first appearances for the first time ever. So NACDL collaborated with the ACLU of New Jersey and the New Jersey Office of the Public Defender to produce this manual that explains the changes to the law and procedure and provides advocacy tips for defenders, the idea being that even with the risk assessment, you still need strong defender advocacy in order to make good decisions regarding pretrial release. The release of the manual was in December of 2016 and was accompanied by 3 one-day training programs in various areas of the state so that we could train those attorneys who would be participating in first appearances and detention hearings. The most recent information that I've heard regarding detention rates, actually the slide says 10% of defendants being detained, but I heard at the Pretrial Innovation Conference convention, rather, last week that the number's actually closer to 15%, which sounded a little bit high to me, but upon further looking into it a little bit more, that is in line with what DC is doing, which is generally upheld as, pretty good pretrial release programs. So we expect to continue to stay in contact with folks in New Jersey to see how things go and make sure that they are following the new statutes that allow for this zealous representation at first appearance. Another update from NACDL, we released a new report about the right to counsel in South Carolina. This was a follow-up to last spring's Summary Injustice report, and we used mostly law students and some lawyers to gather data about what happened in 49 different court sessions throughout the state. And these are in their summary courts, which are, minor misdemeanor courts. Generally, jurisdiction is for crimes that are up to 30 days in jail or up to a $500 fine. There are a few more serious charges that go to these courts, but there are more than 400 summary courts scattered throughout the state of South Carolina, only 46 general sessions courts, which is where more serious misdemeanors and felonies are heard. So there are a bunch of these courts, and what we have found between our 2 studies, the Summary Injustice and Rush to Judgment reports, are that there is a huge lack of counsel in these courts. In our study, fewer than 10% of defendants had counsel. There was frequent failure to inform of rights. More than 1 in 10 defendants observed in this study was assigned to a courtroom in which no advisement of any rights was given at the beginning of the court session. There was also substantial variation among counties regarding what rights were covered. For example, in Orangeburg County, more than 40% of observed cases were in courtrooms where the opening advisement didn't even mention the constitutional right to an attorney at all, much less to the right to an appointed attorney. In more than half of the cases observed, magistrate and municipal judges did have some personal interaction with defendants that gave them the opportunity to provide individualized advisement of rights, but during those interactions, judges routinely failed to address basic constitutional rights. So they would basically open court with some sort of advisement of general rights, but wouldn't actually have any individual discussion with the defendant to make sure that that particular defendant understood his or her rights, understood the rights that they were waiving if they decided to go without counsel, and that sort of thing. More than half of defendants, 50.9%, were not advised of their right to counsel when speaking to the judge. And the last note that I have there, nearly 26% of cases were resolved without a single lawyer involved. What I mean by that, judges are not required to be lawyers in South Carolina's summary courts, and many of them are not. So nearly 26% of the observed defendants had their cases processed without interacting with a single lawyer. This is a case that was prosecuted by a police officer rather than by a state attorney. There was no defense counsel, and the judge hearing the case was not a licensed attorney. That number actually rises significantly if you take out Richland County, which is Columbia, where over 95% of judges had law degrees. So if you exclude Richland County and look only at the other 4 counties that we studied, 89% of defendants that we witnessed were processed in courts without a single lawyer involved whatsoever. So based on that, we did make some recommendations for reform. Number 1, staff summary courts with prosecutors, defenders, and judges who are attorneys. As I mentioned, most of the cases in these summary courts don't even have actual state prosecutors. They are prosecuted by the police officer who arrested or cited the defendant into court, which means that defendants also who don't have counsel are negotiating directly with the police officer who arrested them or cited them when trying to resolve their case. Another suggestion for reform is to decriminalize traffic offenses to lessen the load in these summary courts. Almost all traffic offenses in South Carolina are also criminal offenses that do trigger the right to counsel, and they are, you know, a large portion of the cases that are going into these summary courts, which, you know, makes those much fuller, makes those dockets much heavier, makes it harder for the state to comply with its right to counsel. Third, we think that they should reduce fines and fees and offer alternatives to incarceration for the indigent. For example, state assessments in South Carolina are very high, currently 107.5%. So what I mean by that is if a person is given a $100 fine, there's an extra $107.50 tacked on top of that. We really saw these fines and fees adding up, particularly in shoplifting cases, where indigent defendants were frequently assessed fines, costs, and fees totaling $2,130, plus if they wanted to get on a payment plan, there was an additional 3% tacked onto that. Fourth, South Carolina should start gathering data on whether or not defendants had counsel. They are gathering some limited data in summary courts, mostly about, you know, what the charge was, how long it took to go through the system, you know, the opening date, the close date. They might be doing some collection on demographics, but I'm not sure. But it doesn't seem that they're being very careful about determining whether or not defendants had counsel, whether or not they were advised of their rights to counsel, you know, whether a written or oral waiver was taken or that sort of thing. So we'd like to see a lot more robust data being gathered in South Carolina on counsel issues. And then finally, enacting uniform procedures for advisement of rights and plea colloquies is something that's really important to make sure that we're not just, you know, in some places they are showing a video at the beginning of court that tells you all your rights, which has some very helpful information, but, you know, a video can't answer questions, and if you're not present for the viewing of the video, then you're not getting that information. So we'd really like to see uniform, individualized advisement of rights and plea colloquies to ensure that these folks are understanding what their rights are, and if they choose to waive them, you know, making sure that that's actually their choice and not just something that they sort of feel forced into. So that is all I have, and I'm going to turn it over to Andrea Marsh to talk about the most recent report on Louisiana.
Hi, good afternoon, everyone. I'm Andrea Marsh, and I am the author of the recent NACDL report, State of Crisis, Chronic Neglect and Underfunding of Louisiana's Public Defense System, which was released at the beginning of March. The report is a component of NACDL's contribution to ongoing efforts to address Louisiana's public defense crisis. These ongoing efforts involve many state and national organizations, public defenders, private attorneys, and community groups. And in fact, publication of this report is one of many developments related to Louisiana's public defense system that have occurred in just the past 6 or so weeks. So in addition to the publication of the report, we've seen the dismissal of the federal lawsuit filed by the ACLU. We've seen the filing of new statewide litigation in state court by the Southern Poverty Law Center, the Lawyers Committee, and others, and the publication of SCLADE's workload study for Louisiana. So there is a lot going on in Louisiana, and a lot has been written about what is going on in Louisiana's public defense system. So a fair question, I think, is what this report can add to that conversation, and that's what I want to focus on today. The report places the current crisis in the context of the history of Louisiana's public defense system and goes back to the state's response to Gideon. The report in this way updates the history of Louisiana's public defense system that was provided in a 2004 report commissioned by NACDL. That report is in the Defense of Public Access to Justice. And this new report covers subsequent developments, including passage of the Louisiana Public Defender Act in 2007, the work of the statewide Public Defender Board created by that act, and the 2016 amendments to the Public Defender Act that passed in response to the political fallout from the current crisis. Viewed in this context, the current public defense crisis was not unforeseeable or even unexpected. It's perhaps best characterized not as a standalone crisis, but as the most recent flare-up in a state of perpetual crisis that goes back decades in Louisiana. Judges and state officials have responded to sort of previous flare-ups in this crisis by creating a series of boards that have had increasing powers over the years, but they have never funded those reforms at a level that has allowed them to take root statewide. And so the lesson that we take from this history and that the report kind of lays out is that at this point there is no reason to believe that reform in Louisiana can be successful, at least in the mid to long term, unless it squarely takes on the fiscal issues that have doomed previous cycles of reform that have happened in the state and that have led to similar crises in the past. The report also aims to look broadly at the public defense crisis in Louisiana. A lot of the popular media coverage of the public defense crisis has focused on the consequences of the crisis, which are certainly severe. I think we've all read about wait lists caused by restriction of services and the indefinite detention of accused individuals without access to counsel. A lot of the policy work, policy writing on this has focused on, the causes of the crisis has focused on funding. And that is for good and obvious reasons. As I've already discussed, fixing the funding in Louisiana's system is an essential part of meaningful reform in that state. But in the report, we also found that consistent funding pressures had diverted attention to maintaining solvency of these offices, basically just breaking even on the budget, at the expense of making necessary improvements to the quality of representation. So there are some glaring problems with the quality of representation that have never been addressed either before or after passage of the Public Defender Act in 2007, including mass guilty pleas or lawyers who do not communicate with their clients. The Louisiana Public Defender Board, created in 2007, has never had the staff and resources it needs to train on the performance standards that it develops. And a lack of training on the standards at the district level and a focus on basically just keeping the lights on in some of these offices has undermined defender buy-in for and public messaging around restriction of services during the crisis. So basically, offices were going on and off of wait lists, sort of separate from, independently of what their caseloads were, and really just based on could they maintain solvency over a certain period of time. So our overall findings is that the system needs more funding and a more stable source of funding, but it also needs to refocus on providing representation that meets professional and ethical standards, instead of focusing on merely breaking even on budgets that reflect years of quality compromising budget cuts. The report makes 6 formal recommendations. The first is that the Louisiana legislature should fully fund the provision of public defense services in Louisiana from general revenue. So that recommendation involves both a move to state funding and an increase in funding. The SCLADE workload study clearly demonstrates that the system is underfunded and currently only is about 21% of capacity. Funded at 21% of the capacity needs to provide quality defense services. Recommendation 2 in our report is that the Louisiana legislature should repeal the public defender fee on convictions and the public defender application fee and replace those local funding streams, which are based on tickets, basically convictions on fees, with state general revenue. However, if local revenue is a necessary transitional measure before sufficient state funding is available to fully fund public defense, changes should be made to those local revenue streams that will make them more stable across defender districts. The third recommendation is that Louisiana should establish parity between the defense function and the prosecution. 4, Louisiana judges should respect the independent professional judgment of lawyers who provide public defense services. And this really targets a practice of forcing defenders who have conflicts to remain on cases, despite their independent judgment that they should not maintain representation. Recommendation 5 is that Louisiana judges should release from detention accused individuals for whom the state cannot provide counsel due to its underfunding of the public defense system. Right now, most people who have been held, who are on wait lists and who cannot afford to post bail just remain in jail, and there has been no systemic response to sort of deal with the indefinite detention problem. And the final recommendation is that the state board and the defender community should refocus on improving the quality of representation rather than merely surviving the next crisis. And this really goes to getting out of sort of this defensive posture focused on solvency to recenter themselves on the goal of delivering standards-based representation, even in the face of sort of crushing fiscal pressures. And I'm happy to take questions at the end of the webinar, but right now I will turn it back to the moderator.
Thank you, Andrea. We will turn it over to April right now.
Hi, everyone. Can you hear me?
Yes, we can hear you.
Thank you. So I'm going to be providing updates from attendees who attended the October convening on the right to counsel. So a part of that convening, we had breakout groups, and we talked about what we were going to do individually to go back into our communities and advance the right to counsel. And we surveyed the group of attendees and received feedback about specifically what they were doing in their jurisdictions to advance the right to counsel. We received an update from Virginia, from Bunny Hoffman, the Deputy Public Defender. And in Virginia, they are working on introducing legislation specifically around discovery rules. And as public defenders, we know how important it is to make sure that we have statutes in place that truly affords our clients meaningful right to counsel. So in Virginia, they're currently working on proposing legislation in Virginia to improve discovery in the state of Virginia. We also received an update from Utah, Judge Michael Kwan from Taylorsville Justice Court. We were really happy to hear from him about what he was doing personally in his courtroom to improve the right to counsel. And he went back and expanded his colloquy that he provides to people accused of crimes in the courtroom. And he also talked about resisting the attempts from the executive branch to limit appointments, and also the difficulty in reimbursing attorney fees. So this is really a positive step in Utah, but specifically in the courtroom of Judge Kwan. And we look forward to hearing more from him about his experience in implementing these changes in his courtroom. We also received an update from Kathleen Casey in Indiana, who is a staff attorney, and her update is really more general. We talked about messaging at the last convening, about how to use SEL to message about the importance of right to counsel, and she reported to us that she's using the information and techniques that she learned to actually start a conversation in her state about the right to counsel. Okay, and finally, we had an update from Judge Brian McKenzie, which is really positive. He's taken the step to actually publish an article on the right to counsel, and specifically, he wrote an article to the membership of the American Judges Association about the importance of right to counsel. And he's also following up on that written piece to prepare a presentation along with American University at the mid-year meeting for the American Judges Association. And this is really important work because we know one of our key stakeholders is the judiciary. He also mentioned that he wrote an article for an online publication, and also is promoting the right to counsel through his company's Justice Speakers Institute Facebook page and website. So we were really excited to hear these updates from those who attended the annual convening on right to counsel, and we also encourage people to share with us throughout the year what you're doing in your individual jurisdiction to advance the right to counsel, and we would love to feature your updates on the future webinars. And I think that's it. I'm going to turn it back over to Genevieve.
Thank you, April. I think now we have Amy.
Can you hear me?
Yes, we can hear you.
Okay, great. So Kathleen Casey, who's sitting next to me, was good enough to send in information about Indiana's Smart on Juvenile Justice program. And we're really excited to be doing something to promote right to counsel in juvenile cases. We received through the Indiana Public Defender Council grant in Indiana from the Office of Juvenile Justice and Delinquency Prevention in 2015, a planning grant to come up with a state plan to improve indigent juvenile defense services and to improve our systems. So we were one of 4 states that received a planning grant. And through that, we were, each state was tasked to come up with a state plan. We had an advisory board, a really large statewide stakeholder group that included judges, public defenders from all over the state, prosecutors, probation, and we identified some of the gaps in the system. One thing that Indiana was working off of was in 2006, we went through the assessment from National Juvenile Defender Center, and they did a access to counsel and quality of representation in juvenile delinquency cases for us. So 10 years ago, the problems that were identified as a part of that assessment are in a large part still in existence. We were addressing things like the high rate of kids still going through the system without ever having had an attorney. We were addressing things like a lack of direct appeals in juvenile cases and a really inconsistent quality of representation in juvenile cases. So one thing that, forgot to advance my slides, sorry about that. So this is the federal funding that we received. As a follow-up to the planning grant, Indiana was one of 2 states that was awarded an implementation grant from OJJDP. And so we're about halfway through the first year of that implementation grant. We're in the process now of trying to acquire state funding to sustain the improvements that we're putting into place. One of the things that one of our goals is to ensure that all youth have access to counsel at critical stages, including early appointment, at detention hearings and initial hearings. And Indiana law provides for that, but what was found during the assessment in 2006, and is still the case in many places, is that kids were being allowed to waive their right to counsel before they ever met with an attorney. So even though they had a right to an attorney and one should have been appointed at the first time the kids met with a judge, they were allowing kids to waive their rights. The assessment found that in some counties up to 80% of the kids were going through the system without attorneys, so 80% of the kids were waiving their rights. What we found in the planning process was that we made some improvements over the 10 years since the assessment. We have a fairly new rule in Indiana that limits that ability to take a waiver from a youth and requires the appointment of counsel before a kid can waive their right in some cases. So what we found was over a one-year period after that took effect, the rates of unrepresented kids went down slightly. So it had some effect. So statewide in 2014, the data we looked at showed about 43% of the kids were unrepresented. That's statewide. In 2015, which was the year that that new rule took effect, about 35.5% of the kids went through unrepresented. So it had some effect, but it wasn't being applied as it was written. We have 92 counties. They do things 92 ways. We're a home rule state. So there were some issues and still are with some courts not following that rule. So one of our goals is to make sure that kids do have counsel when they're supposed to and have access to counsel. The second goal that we've been working on is to create a strong system of post-dispositional representation for youth through increased state resources, including appellate representation and civil legal services upon reentry. We found in looking at the data in Indiana, we looked at a 6-year period when we were in the planning grant and looked at how many juvenile delinquency appeals were being done in the state. And over 6 years, we had found that I think it was about 290, somewhere around 290 appeals had been done in that 6-year period. And about 60% of those were from one county, and that's the county that Indianapolis is in. And it's kind of telling that that is the only county that has a separate juvenile public defender separate juvenile public defender office with full-time staff, and that is also the only county that has a separate public defender appellate office with full-time staff. We found that over half the counties in the state had not had a single juvenile delinquency appeal in 6 years. So one of the things that we have been able to do through this implementation grant into our planning is to create we reached a memorandum of understanding with our Department of Correction, and we were able to set up a system where we're going to provide orientation and intake on legal rights to kids coming into the Department of Correction. And then we've set up a system to connect kids that are still within their time period for appeal and qualified to get an attorney appointed and to get some appellate representation. So we are excited to develop some appellate case law on some of the issues that we're seeing. And we've got a trial unit here that's going to work with trial-level public defenders to develop some of those issues that we see as coming up and being important. The third goal was to create a system of comprehensive and thorough legal advocacy, recognizing juvenile defense as a specialization. And as I said before, we're county-based. We've got 92 counties. Every county, we have a lot of different public defender delivery services in Indiana. Some of them work better than others. We have a lot of attorneys that just do a bit of juvenile delinquency here and there. And so training is on juvenile-specific issues is a big need. We're developing juvenile-specific training using the JTIP model from National Juvenile Defender Center, and it's kind of an interactive, almost like a trial practice system. And we're going to do regional free juvenile-specific training throughout the state, and we should be starting that in May. So that's another thing that we're pretty excited about. We're also providing some technical assistance for trial-level juvenile public defenders as we go forward. And then the last thing was through this process, we're trying to enhance our juvenile data collection to promote accuracy and collect key defense data indicators statewide. What we found was that the data that is available statewide isn't very reliable. We've had to cobble it together from a lot of different sources. We know that some of the data reported at the state level by counties isn't accurate. I mean, you can tell just by looking at some of it. So we're working to develop 2 to 4 pilot sites that we can work on best practices with, provide some concentrated assistance on some of the things I just talked about, and also work with them on data collection to look at key defense data indicators. So National Juvenile Defender Center is our technical assistance provider for the grant that we're under, and they have also been working on a data indicators project and have been very helpful with that. Our main thing that we are facing right now is trying to get the state to invest in this juvenile defense improvement. When we went from the planning grant and we're applying for implementation grant, we were really pleasantly surprised to get bipartisan support, both from our state representatives and our federal representatives. And so we're hoping now we're in a budget session that translates into some state support. So that's all I had, unless anybody had any questions.
I think we're going to wait to do questions till the end, so I'm going to pass it over to Renate.
Assume you can hear me okay?
Yes, we can hear you.
Okay. So this Saturday, the 18th, is the 54th anniversary of Gideon versus Wainwright, and marks the 2nd annual Public Defense Day. So let's go to the next slide, and I can show you what we did last year. So last year was our first Public Defense Day. National Association of Public Defense, NAPD, coordinated it. We developed the Tipping the Scales logo that was done by a paralegal at Legal Aid New York City's office, and we saw that logo. We used it in our social media campaign, and it even ended up on a cake in our public defense office. I think that was in Idaho, but I'm not sure. So the way it ended up being celebrated was last year, I think it was a Friday, so offices had parties like the Tipping the Scales cake, taco bars, ice cream bars, pizza. The upper left-hand corner, the side of the left, shows the King County Public Defender's Office in Seattle. They got a proclamation from the mayor, I think, like announcing that it was Public Defense Day or something like that. So there were different local proclamations and recognitions, and there were even several elected officials who then tweeted about Public Defense Day, the day of celebration in the offices, and then also we did a big social media campaign with the hashtag Public Defense Day, and we're pleasantly surprised to see large organizations like the Marshall Project recognizing it as well. And we got some minor celebrities to tweet about it. And our membership on social media, it was really sweet to see on Facebook several people I know who are public defenders would comment on or made posts on Facebook, something to the effect of, look, I never talk about my work. I usually just post pictures of my kids on Facebook, but it's Public Defense Day, so I want to talk a little bit about the work I do and why it's important to me. And then you'd see, you know, Uncle Bob comment, really proud of you, son. That's good work that you're doing. I didn't realize you were doing that. So it was a sort of a great day for us to sort of pat ourselves on the back and then get some recognition from a variety of different places for the work that we do that often goes unrecognized. So, and then there was also, there were events in courthouses with elected officials in Brooklyn. I think Legal Aid Society co-sponsored event with Brooklyn Defender Services, and we had some city council members, speakers come and talk, and public defense talk about our work in the ceremonial courtroom. And some PD offices had letters to the editor and op-eds published around Public Defense Day about the importance of public defenders. So let's go to the next slide and we can talk about what we're doing this week. Since Public Defense Day falls on a Saturday, we're celebrating Public Defense Week. You can see we have our Tipping the Scales of Justice logo. That courtesy, again, is Celia Gibbons. I have to give her a huge shout out for all her work on this. We decided on 4 issue areas that we wanted to touch upon, focus on for the first 4 days of the week. So bail, fines and fees, the idea of debtors' prisons. Yesterday we did a lot of social media around those issues and what public defenders are doing and what innovative practices public defenders are doing. Today we're highlighting the work of death penalty lawyers. Tomorrow we're going to focus on racial injustice in the court system, and Thursday on juvenile rights. Each day we also want to raise up the work of different member offices and agencies. So yesterday I published something on Facebook about Washington Appellate Project campaign to reduce some of the fees associated with appeals. And Thursday I got an email from Kathleen Casey about the work that she just talked about in Indiana, and we'll make sure that we highlight that on Facebook and on Twitter as well. Friday is a day of celebration, so we expect more pictures of office luncheons and maybe celebrating after work. And Saturday is a day to celebrate in the community the work that we do. So let's go to the next slide, and I can talk about some of the resources that we've created for NAPD members. So NAPD is, there are individual members, and then there are also public defense agencies who are members, and therefore anybody who is a employee of that public defense agency is also a member and has access. Membership gives you access to mygideon.org. And on mygideon, we created fact sheets for each of the 4 issues. Those fact sheets include a resource guide where you can get more information, as well as talking points and sample tweets to use, including hashtags. We also did a series of tutorials. This came out of last year. It was easier for large organizations that have communication staff to publish op-eds and to be active on Twitter. But the smaller agencies that just may have like a 5-person office or a 3-person office don't really have that capacity. So we have guides to how to write an op-ed, how to use Twitter, how to use Canva to modify your graphics, and then we also supplied a number of graphics that people can modify with instructions for how to modify them, so you can add your own agency's logo on them. That's it for mygideon. Oh, I guess I should also make a plug for NAPD that this week there is, we've reduced our membership fees. I think it's something relatively low, like $10 a year. So if people aren't members, perhaps they'll be inclined to consider it. And then Saturday we talked about a day of celebration, so let's go to the next slide and I can talk about Consortium for Indigent Defense. I believe Stephen Saloom is on this call. This is his baby. He's organized concert in New Orleans, but I think there's also a concert that's going to be happening in Bridgeport, Connecticut, and in Denver, Colorado. The Denver, Colorado one is actually featuring public defenders. So the idea is simple, and you can get more information at consortsforindigentdefense.org. This is just a screenshot of their webpage. Concerts for Indigent Defense, the idea is that musicians will dedicate their concerts on March 18th to indigent defense. That's sort of it. This is not a fundraiser. This is not that they're donating ticket sales to indigent defense. They're not committing to making a long and passionate speech of indigent defense, although I understand at the New Orleans concert, the head of New Orleans Office of Public Defender will be speaking. But the idea is just to raise some awareness about indigent defense, and people can still set up concerts, or if they're already planning on playing a gig anyhow on March 18th, they can do a shout out to indigent defense on that day. So that's our celebration. That concert will also be simulcast online, so those of us who don't live in New Orleans and maybe live someplace colder, snowier, icier can curl up at home with our laptops and enjoy some good music and celebrating the work that we do. So we can go to the last slide. Follow us on Facebook. We created an event for this. We also created, I put the Action Sprout website there. So we created even an overlay, sort of like a frame that you can do around your Facebook profile picture that features our Chipping the Scales logo, again, to promote the day. And we're using the listed hashtags on Twitter, Celebrate Public Defense, Defend Gideon, and Tipping the Scales. But just talking to friends and family, not even the media, about the work we do seems to also, I think, is also an important and kind of profound act, even in its simplicity. So I wish you all a happy Public Defense Week, and hope you do something fun to celebrate on Friday. Thanks.
Thank you, Renata. So we are still available to take questions. And Genevieve, do you want to do announcements now?
Yeah, if you have any questions or announcements you'd like to add, I know that Stephen Sloom is on the line, so Anna, if we want to unmute him, if there's anything you'd like to add about the Concerts for Indigent Defense, and if there's anybody else who would like to make an announcement, there's next to your, on the right-hand side, you can see a little hand. If you click on that, it's the raise hand function, and it lets us know that you would like to speak, and so we can unmute you and get to you, or you can send us a question or an announcement in the Q&A that we can share. Everyone?
Hi, yeah, and this is Steve, and I just want to thank Renata because not only for really doing a great job explaining what Concerts for Indigent Defense is, but also to NAPD for their support on this, and but it's been great. We're going to roll it out in New Orleans this year. Just so you all know, the show is going to be from roughly from 5 to 7 p.m. Central Time on this Saturday, and it should be a lot of fun. And it's not. It will be a 2-hour production that will feature a whole bunch of different excellent local musicians from New Orleans, interspersed with interviews with them, pre-recorded interviews with them about why they care about the issue and how it's impacted them and their families and why they're doing this. And so it should be a pretty powerful event. And the hope is that, the hope and the plan is that, excuse me, this will be a model for how defenders and supporters of public defenders in states across the country can have their local musicians do something similar in the future. And just a way, the whole point, the whole idea that I've been toying with this idea for over a dozen years, and the whole idea of it is simply to find a very simple and uncomplicated way, at least on one day a year, to, excuse me, be able to draw in public attention to this really valued constitutional right that is crucial to our court system's ability to do justice, and therefore crucial to all of us. And that's kind of the frame of the message as well. So many thanks to NAPD and all of you for all that you do, and the good folks in New Orleans. I just had to hop off the webinar for a radio interview with the NPR station down there that the Orleans Public Defender set up for us. So it's going to be great, and we appreciate you all are welcome to pitch in, ask questions, tune in, and if there's anything you want to do in the future, let us know.
Great, thank you so much. That sounds really wonderful, and hopefully there'll be many more concerts to come. So it doesn't look like we've received any other questions or announcements. So if you have anything at this time, please, feel free to submit it or use the raise hand function. And otherwise, I just want to thank everybody for staying on. We had 20 attendees that stayed on the entire time, so it's really wonderful for an hour-and-a-half webinar. And thank you so much to all of our presenters for joining us today. If you have any other questions about the Right to Counsel National Campaign or want to be involved, please feel to reach out to myself. My email address and the phone number are there, and you can also visit the Right to Counsel National Campaign website, which is rtcnationalcampaign.org. So thank you all very much. Have a wonderful day.